lecture for Journalism 302 in the summer of 2017. This lecture should have been a Friday blog, but as I've communicated to you, technology has not been helpful. So this lecture will consist of the Friday blog as well as the next lecture for the class. You're very interested in this information about the test. Originally planned, the PolyLearn would have had the test open to you for a 3-hour window. That is conflicting with some of your schedules, and PolyLearn is being difficult, so I'm simply going back to the old-fashioned way of doing this, which is I will send you the test by email Thursday at noon. You will have 24 hours to finish it and return it by email. So that should accommodate pretty much anybody. If it is a problem for anyone, give me an email right away so that I can get you a test so we can move the class forward. There was a question in your blogs about anonymity and test taking. When you write your answers, you'll use your employee ID and not identify yourself in any way. If you identify yourself in any way, you lose 20 points off the top of your grade. That's a bad thing, and I have had students in previous quarters put their names on their blue books or identify themselves in the body of a question. They'll say, I Judge John Smith rule this way, and I will have to write next to that, well, Judge John Smith, you've just lost 20 points because this is supposed to be anonymous grading. When you send me your test answers by email, you'll send them to beloving@calpoly.edu. Don't use the Prof Loving blog's email address. Send it to my Cal Poly email address directly. Now you'll get an automatic response, but don't worry about that. You should attach your answer as a Word file, and for the name of your file, say test1 and your employee ID. I'll then open the attachments, copy all of your test answers into new files with numbers from 1 to 25. And these will be randomly generated. You should also include your test answer in the body of your email because occasionally, sometimes Word attachments or whatever program you're using will not open. So that gives me an option to be able to get your test even if the attachment does not open. Now, I won't know what number belongs to which student, so you are anonymous to me. I like to grade on content and not on personalities, and it works better that way. When the tests are graded, all the tests are graded, I'll match up your employee ID numbers, and then I'll send you your graded test back by email. Let's move on to some of your blog questions. Oh, but before we do that, anonymity and test taking. You've been in classes, and you know that in some classes there are students who are eager and always wanting to answer the question and be involved. And there are other students who are, well, it was either be in class or go to jail, so they're choosing to be in class, but they're not happy about it. When I first started teaching, I had students who ranged all along that spectrum. And for the first test I did, I would be grading a test and saying, oh my goodness, this student is so helpful in class, so eager to participate, but the answer is completely wrong. But I like this student so much. And then I would say, but there's punctuation. And of course, punctuation is a part of a correct answer. Therefore, the student makes 100. And then there would be the other kind of student. And I would say, oh my gosh, this answer looks perfect, even though this is a terrible student. And then I would say, oh my goodness, there's a misspelling. Of course, misspelling means the word is wrong, and if the word is wrong, then the whole test must be wrong. 0. I actually wouldn't do those things, but that's my rhetorical hyperbole. So I found that when I made all the tests anonymous, I didn't have to worry about the, oh, this is a great student, I feel so bad the student did poorly, or this is a terrible student, I feel so bad the student did so great. In reality, I don't feel bad about anybody doing great. I want all of you to do great. So I found that the anonymous testing was most helpful to me. I didn't have to agonize over trying to understand and interpret a correct answer out of one that was bad. So that's how things go. Let's move on to your blog questions. I'm picking them from your blogs, and the blogs are helpful to me to understand what you're getting and what you're not getting and what I should go over again. Details of the cases. Details of the cases can be important to you in that you may find some similarities. But understand that it's unlikely that the legal controversies will be an exact copy of the cases in your book. So it's necessary for you to be able to spot the issue, which is a tricky thing. Know the rule of law for that kind of issue, and the rule of law comes from prior cases. Apply the rule of law, and prior cases show how the rule is applied, and then come to your conclusion. You have to show your work on your test answers. The conclusion, so-and-so wins, so-and-so loses, that's the least valuable part of your answer. That's like 2 points out of 50 or 2 points out of 33. The points come from your showing me your work, demonstrating that you know how the law works. Because when you're out there practicing as a journalist or even as a lawyer, you're going to have to understand how the law works in order to come to the right conclusions and be able to protect yourself and advance your own rights. Another question, of course, strict liability crimes were covered in the introductory lectures. And the question is, where is the line drawn? And can you fight a strict liability crime? Well, not really. If you can prove the fact is not correct, as in your headlight was working and you have video of the headlight working as the officer was writing you the ticket, or that the meter hadn't expired and you have video showing the meter was still clicking away when the officer was writing the ticket, then you can do that. But you can't defend a strict liability crime by saying, well, I didn't have the mens rea. Now, strict liability crimes exist because society says certain things need to happen. And it doesn't matter why you did it or why you didn't do it. We simply need things to happen or not happen in order for society to work very well. So for parking meters, they don't want people to hog the parking spaces. They want other people to have a chance to park and do business. If strict liability crimes had a mens rea component, then imagine all the excuses people would give as to why they were at the meter after the meter ran out. I was in a coma. I was kidnapped by space aliens. I was asleep. I was drunk. And because I was not thinking about the parking meter, I can't be convicted and I don't have to pay the ticket. Well, society and the legislature have said, look, we don't care why you stayed too long at the parking meter. The fact that you stayed too long at the parking meter is enough for you to have to pay the ticket. And similarly, for if your headlight is out and the rule says you have to have operating headlights, it doesn't matter that you knew the headlight was out or that you intended to drive without a headlight. The rule is there for society to work better. And so there is no defense of, I didn't know my headlight was out. Question going back to another introductory video, the Liebeck versus McDonald's case. Of course, you'll remember from the lecture that she won $2.7 million and there were punitive damages. It was reduced by the judge. How does the jury come to the conclusion about the amount of the award? Well, lawyers for the plaintiffs will suggest numbers, and based upon the facts, the jury comes up with a figure that will compensate the plaintiff for her injury. Now, the Liebeck case also involved punitive damages, and punitive damages are intended to deter further bad action. So, Miss Liebeck has been injured, she has medical costs, she has pain and suffering, and that's part of the award to her. The biggest part of the award was the punitive damage. And what the jury was doing in that case is saying to McDonald's, look, you might just ignore how you serve coffee, because if you only compensate Miss Liebeck for her actual losses, it's not a big deal for a billion-dollar company like you. But if we make you give her an additional $2 million, then that's going to make you stop and think. Because now you're going to have to pay her the $2 million. If you keep your coffee at the same temperature, you're going to have to pay a lot more people $2 million, and that's going to eat into your profits, and that will get the attention of a corporation. In that case, the judge reduced the amount of the damage because the judge has the power and the discretion to lower awards when the judge feels the award was unreasonable based upon the facts of the case. If the jury is simply very upset at McDonald's and wants to make a point, or they're angry because their Happy Meal didn't have a toy the last time they went, and they pretty much want to take it out on McDonald's, then the judge has the ability to reduce the amount of damages. That reduction in damage can be reviewed by an appellate court, and the appellate court could restore the original judgment or agree with the judge that the judgment that the jury came up with was too much. Here's a question with respect to the different protections that states afford to media. Understand that the First Amendment applies to everybody, federal government, state government, regional, and local. And states can create additional protections for expression. Now, we're not going to have questions about administrative prior restraint. That is to say, a school administrator says, you have to take this story out of the paper, or we're not going to let you deliver the yearbook. We're not going to have those, because when you graduate and you're out there in the media, you're not going to be a student reporter, and you certainly won't be a high school reporter. But it's important for you to understand that some states have protections for student journalists and apply them when necessary. Here's a question that involves a subject matter that we're going to cover later in the lecture, but I figured, what the heck, it's a blog question. And I'm assuming that many of you have already read through the pornography section of the textbook. So, pornography. And this question is based upon the fact that we came up with a really bad term to describe child pornography. Understand that child pornography is not pornography. It's also not obscenity, and we'll cover both of those in the lecture that follows. What child pornography is a term used to describe the sexual abuse of minors that has been produced, performed, distributed, and received by people. It is just against the law to sexually abuse minors. And child pornography, well, somebody came up with that term without thinking it through, which means that a lot of people confuse child pornography with pornography and even obscenity. But child pornography is not that. Child pornography is completely against the law. Now, as we'll see in the lecture later, that there is pornography, which is protected by the First Amendment, and then there is obscenity, which is not protected by the First Amendment, and there is a three-part test to determine whether something is pornography or something is obscenity, and we'll cover that later on in the lecture. So, just keep in mind, child porn, don't think of it using the term pornography, just think of it as a crime to sexually abuse minors. And as we saw in the Matthews case, it's a law of general applicability. So therefore, the First Amendment will not apply. Okay, another question about Matthews versus United States. Could he have told somebody in law enforcement he was doing a story on child porn? Well, he could have. And in fact, before he retired, when he was working on stories about child porn and interviewing people in law enforcement, he was aware of what they were doing. Now, when he did his stories about child porn, he was not going undercover to try to win the confidence of a child porn consumer. One of the problems with Mr. Matthews going to law enforcement is that law enforcement might have chosen not to arrest him, but it would still have been a crime. And if they had chosen not to arrest him, then they were going to expect something in return. And that would have been, once he got online and met people who consume this evidence of child sexual abuse, and they talked to him and they met with him, law enforcement would expect him to turn them over so that they could prosecute, convict, and send those people to prison. And Matthews would have known that. So he would have wound up lying to people to try to get them to open up to him. And he might not have wanted to do that. There was a second concern, and that is that cooperating with law enforcement can sometimes make a journalist an agent of the law. And if you become an agent of the law, it's kind of tough because, as the saying goes, no person can serve two masters. Here we have a question relating to current events. Kathy Lee Gifford and the Trump head photograph. And should she have gotten in trouble? Should she have been prosecuted for this? And remember, of course, from the Yates case and mostly the Yates case, that unless there is a call to action, and comedy is considered to be a rhetorical hyperbole, that is to say, it's an outrageous exaggeration and not really advocacy, then it's not taken as a literal call, so she was not, in fact, trying to get people to assassinate the sitting president. Injunctions, prior restraint. How long does it take to get an injunction? All you have to do to get a temporary injunction / restraining order is go in to see a judge, talk the judge into issuing the order, and then getting the order and serving it on the newspaper, website, station, whatever. It's not a long, drawn-out process. You don't have to provide your background. You just go to the judge and say, Judge, this terrible thing is about to happen unless we prevent these people from publishing, broadcasting, posting this information. And if you talk the judge into it, you can get this done in as little as 15 minutes. So it's not a long, drawn-out process. Now, the long, drawn-out process comes once the temporary injunction has been served and the immediate defendant goes to court to argue that it's not correct to restrain the publication. And here's a suggestion. Maybe there should be a different system for determining when a prior restraint is constitutional or not. And keep in mind that this rule has been in place for more than half a century. It works well. And it's true that courts will interpret things differently. When they have a different interpretations, you just have to keep in mind that judges are people. And just because they wear black robes and sit up higher than anybody else doesn't mean they're infallible. I've covered both federal and state courts and have looked at judges who were biased, prejudiced, and in a couple of cases, crazy. In my opinion, they were certifiable. But they'd been elected by the public and re-elected, so they got to wield the gavel and make their own judgments. I recall one particular federal judge. I won't give you his name because I don't want to stir up a big pot, but his nickname was Maximum and then his name. And the problem with this one particular federal judge is that his interpretations were just not right, and that 70% of his convictions, when appealed, were reversed. So, there's a judge who obviously didn't have it down correctly. And the appeals process is how we correct the poor interpretations of judges. So the three-part rule, that's the constitutional test for prior restraint. And if a lower court judge gets it wrong, we have to hope that an appellate court will in fact correct that misinterpretation. Question about English law. And of course this will apply to pornography as well, which we will get to later on in this lecture. Remember that America started out as a set of English colonies, so we had English law. The lawyers and judges were trained in English law, and when America became independent, that law training and practice was continued. It's like we can either use the system we're accustomed to, that we've been trained in, that we're experienced in, or we can try to create a whole new set of law, and that's a massive undertaking. So they just continue to do things the way they used to do them. Keep in mind the fact that we still spoke English, right? We were now independent, but we still spoke English. We didn't say we're going to have a brand new language. No, because we're accustomed to English, and we were accustomed to English law, so we kept that. Now, after we were independent and American law developed, American courts would sometimes look at cases from other countries. England most often, because it was the system most similar to ours. Europeans use civil law, which is not to be confused with civil court, and the French used later Napoleonic law, but English law was still the most similar to ours. They had cases and controversies that were similar to what we would encounter in the United States. And so American courts would say, well, the English have already dealt with this and they've come up with this rule. We're just going to borrow this rule because we see this court case from England is valuable to us. Keep in mind that for some years, after Barack Obama was elected president, and people some people were of the belief that he was Muslim, that people were scared to death that Sharia law would be applied in the United States, because, well, after all, he's a Muslim president, which of course wasn't true, but people still clung to that mistaken belief. And as a part of that mindset, it was, well, he's going to make us all use Islamic law. It was so prevalent that some states made changes to their laws and constitutions to prevent any foreign law from being applied in state courts. Some specifically singled out Sharia law. Now, at the same time, remember that many of these people want to see the Ten Commandments put in courthouses and applied to American law. Well, those people who didn't want religious law to be applied, or foreign religious law especially to be applied, need to keep in mind that the Ten Commandments are religiously based and were not written in America, so go figure. All right, let's move back into prior restraint. Remember, we left off with the progressive case, and now we have the Oklahoma City bombing case, which helps us to understand how changes in society, and more particularly changes in technology, have affected the law. So April 19th in 1995, Timothy McVeigh and Ed Nichols bombed the Alfred P. Murrah Federal Building in Oklahoma City. They killed 168 men, women, and children. Yes, there was a daycare center in the Murrah Building, and both McVeigh and Nichols knew there was a daycare center and that there were kids there, toddlers, infants, and they thought that it would make more of a point if they blew up the building with the kids there. April 19th, an important date for some folks in the country. April 19th was the Ruby Ridge incident, where federal agents shot and killed the wife of nationalist. April 19th, also the Waco federal attack on the Branch Davidian compound in Waco, which resulted in numerous deaths, and then the Oklahoma City bombing. So McVeigh was arrested driving away from Oklahoma City. His car didn't have a license plate, and McVeigh is acting strangely. When McVeigh and Nichols were planning the bombing, they decided that they would get a rental truck, which would be large enough to hold the components of the bomb. And if the truck was going to carry the bomb to the Murrah Building, there would have to be a way for McVeigh to get away. So they took Nichols' car, parked it a few blocks away. McVeigh pulls the truck up in front of the Murrah Building. He's already set the fuses. He gets out, throws the keys away, walks to the car, drives off. Now, they're concerned that cameras in Oklahoma City, in downtown Oklahoma City, might catch video of McVeigh in the car. They didn't want the federal authorities to be able to look at the license plate and they're say, well, that's Ed Nichols' car, so let's go arrest those folks. So they took the license plate off and threw the plate into a creek to foil the cameras in downtown Oklahoma City. But they didn't count on the fact that a car without license plates would be suspicious. And so a trooper stopped McVeigh, noticed he was acting very strangely, had already heard about the explosion in Oklahoma City, and so the trooper took him into custody, and he was held in custody until they arrested him in connection with the bombing, and then he faced trial. After he was charged, McVeigh was appointed defense lawyers. The government paid for his defense. And he told his story to the defense team. Ben Fenwick, who was my graduate assistant, former graduate assistant, gets a copy of what later would be known as the McVeigh Confession. I was in my office. He called me and said, "Can I come by and show you something?" I said, "Sure, I'll be here." He came into the office. He had a big, thick stack of papers. He put them on my desk and said, "Take a look at this." And so I start leafing through the pages, and I see that it is information from Timothy McVeigh about the bombing, about why he did the bombing, how they did the bombing. In your textbook, there is a section from that in which McVeigh talks about pulling up in front of the building and seeing one of the people he's about to kill, a woman with dirty blonde hair who is walking into the federal building as he is setting the fuses and then getting out of the truck. She's going to die in a few minutes, and McVeigh sees her. Now, at this point in class, hands would go up and say, "Well, how did Ben get that confession?" And for every year that I've taught the course since the bombing, I've had to tell students, I can't tell you. But from my conversation, it was clear that this was, in fact, a bona fide document from the case. One of the reasons that Ben Fenwick came to me is, well, two reasons. Number one, he wanted to know how to protect himself, and the second, he wanted to know how to be able to publish the story without being restrained by the trial court judge. Now, we've been talking about prior restraints and the conflict between the First Amendment and freedom of the press, freedom of expression, and the government's view that certain things should not be published. We're going to add into the mix the Sixth Amendment. The Sixth Amendment is the amendment that guarantees people the right to a fair trial. And so judges are responsible for ensuring that defendants get a fair trial. If the McVeigh Confession is published and people all over the country read it, then people will have formed an opinion as to his guilt, and so he would not get the, quote, fair trial. It might make it impossible to find a jury that could judge him fairly. And we had a previous example in the trial of Oliver North and Admiral Oliver Poindexter in the Iran-Contra scandal. The trial was conducted up at the District of Columbia because everybody knew about the scandal. There had been Senate hearings about the scandal. They had trouble coming up with enough people on the jury who didn't know about what happened. And so it turned out that one of the jurors was seated on the jury, and she decided to wear her Starfleet Academy uniform to the trial. Now, some people would have questions whether or not the person should serve as a juror, but the person was qualified. There was no problem with the person's judgment, but the person was a little quirky. And while that might not keep her on the jury for the Iran-Contra criminal trials, they were so hard up that she served on the jury. So here, The presiding judge would have to consider, if he heard about the confession being published, what would happen to McVeigh's Sixth Amendment rights, and the judge could impose a prior restraint. And a prior restraint under these circumstances would work. So, there you have it. It would be constitutional. Now, here we have technology in society. Back in 1995 and 96, the internet was becoming more widespread, more adopters. And I was in my office one day looking at news on the internet, and there was a story about the Dallas Morning News. And the story was about the fact that the Dallas Morning News had a reporter write a story. The reporter then sent it to a copy editor. The copy editor edited the story and sent it to the place where they set up the pages for printing at the printing press. But the copy editor sent a second copy of the story to the Dallas Morning News website operation. So, as the Morning News explained, its web story was published to the public hours before the print version of the story landed on people's doorsteps in the morning, which was very interesting and caused this proverbial light bulb to go off over my head, because I had been trying to figure out how to get the story published without running into the problem of a prior restraint. Ben had sold his story to Playboy magazine. Now, Playboy is more than just articles about fast cars and liquor and naked pictures. It also has done and published a lot of solid investigative reporting. So Fenwick sold his story to Playboy. They couldn't figure out how to publish it without a prior restraint. I couldn't figure it out. I was up in Chicago at Playboy headquarters trying to figure out what we could do. We thought at one point that if the judge sequestered the jury, in other words, he would pick the jury, sequestration, which we'll cover in the Free Press Fair Trial section, is where you lock up the jury. They stay at a motel, they eat their meals together, they don't get to consume media freely, and by locking them up, they are shielded from any sort of publicity, any sort of story that might affect their judgment and prejudice them with respect to the defendant. But the judge picked the jury and didn't sequester them. He simply sent them home and said, don't read about this in the news or anywhere else, and then when you come back for the trial, you should not have an opinion as to Mr. McVeigh or Mr. Nichols' guilt or innocence. Well, sequestration was out, so we had no idea. As in the Progressive case, Playboy would promote the story. Coming next month, the McVeigh confession, we give you the story about how he became radicalized and how he killed all those men, women, and children in Oklahoma City. And when that came out, the promotion for the next month, the judge would hear about it. He would shut down Playboy. Or if Playboy didn't promote it, in the production process, somebody might blab. Somebody working at the printing press. Oh, wow, they have this story about the McVeigh confession. And that person might talk to somebody else, who might talk to somebody else. And the risk was that word would get back to the judge, and the judge would impose a prior restraint. Now, you'll remember from the Progressive case, right? Judge Warren dissolves his injunction because it no longer is effective, because the same or similar information has been published by the Madison Press Connection in some other newspapers and in a letter to Senator Charles Percy of Illinois. Well, I put together two things. One, the ability of the Dallas Morning News to publish its story on the internet hours before the newspaper version came out. And two, the need for prior restraints to be effective, to be constitutional. So I contacted Playboy and I said, we can publish the story. You just put it up on the internet first. If it's on the internet, then you can publish the story in the magazine, and the judge cannot stop the magazine publication. And so the editors at Playboy were very happy. They originally had planned to do a 3,000-word excerpt on the internet after the magazine came out, but they flipped things over so that Fenwick then redid the story in its entirety for the internet, and it went up, and of course it made a big splash. It was covered by all the major networks. And then Playboy announced, coming up next month, we have the McVeigh confession. And the judge didn't do anything, because the judge couldn't do anything. It had already been published on the internet. Therefore, if the judge tried to impose a prior restraint on the physical magazine, he couldn't, because it wouldn't be effective. So that's the key. If the story is out, then the prior restraint will not be effective. It's not effective. It's not constitutional. Oh, the ABC Primetime Live. I made a deal for Ben to go on the ABC News magazine to talk about the confession and how he got, well, and the case. So the internet and prior restraint. You've heard of WikiLeaks. Before it became famous for all the national security stuff, it was known as a website that invited people to post leaked materials. And the people posting these leaked materials usually were from the world of business and banking. So people would say, my bank is doing terrible things. Here are documents showing they're doing terrible things. Well, a lot of times those document releases would come as banks were being sued. And in one case, back in 2008, a case was being heard in federal district court, being heard by Judge Jeffrey White, and somebody was leaking internal bank documents to WikiLeaks, which was then posting them on the internet. And Judge White says, well, this is terrible. The case is supposed to be decided upon the evidence that I, as the judge, allow into the courtroom. And so he issues an injunction to the domain name registrar to lock up wikileaks.org, lock up the site. WikiLeaks can't publish anymore. So he figures he's solved the problem. Well, everybody gets all hot and bothered by this. News organizations run editorials about how dumb this is and how bad this is. And Judge White, in addition to the public condemnation, finds out that wikileaks.org may have been shut down as wikileaks.org, but it continues to exist and publish on mirror sites. And some of these mirror sites are registered in foreign countries. And a federal judge has no power over the internet in foreign countries. So, hang on here. This is the thing about the internet and prior restraint. If you think that a judge is going to issue a prior restraint against your publication, either your newscast or your newspaper or magazine, if you beat the judge to the draw, then the judge is likely not to issue the prior restraint to begin with, or if the judge does issue a prior restraint, you'll be able to successfully challenge that prior restraint in court because it doesn't pass the three-part test. So that's how the change in technology in society has affected prior restraint. It's really difficult anymore to be able to get a prior restraint because people are naturally going to publish online if they get the slightest hint that a judge might issue a prior restraint. Now, notice the words hint that a judge might. If the judge has issued a prior restraint and you get served with that prior restraint, you cannot then put it up on the internet. Because once you have the prior restraint, once you've been served with the document, then you can't publish anything. And if you do, then you're in contempt of court and the judge can order all sorts of sanctions and penalties against you. And if you try to fight it, remember collateral bar, says that your attempt to appeal the unconstitutional prior restraint can be stricken by the court because you haven't been playing by the rules. You've forfeited your right to appeal. But that's an important thing. We now have a situation where it's really tough for prior restraints to be imposed here. Doesn't mean that they can't, which comes over here to giving up rights against prior restraint. You can enter into a contract in which you allow somebody to enforce prior restraint against you. If any of you are thinking about going to work for the CIA, understand that the CIA makes you sign all sorts of agreements that say you can't publish or disclose or speak about anything you learn while you work for the CIA. And we have several cases. We have Victor Marchetti. Now, Victor Marchetti was a CIA agent who became disillusioned with the agency. He wrote a book, The CIA and the Cult of Intelligence. He had signed a non-disclosure agreement with the CIA. The book was in production, that is to say they were producing the book, making up all the pages, typesetting it, when the CIA found out about it, and they said, you can't do this. So they went to federal court and told the judge, Mr. Marchetti, who's a former CIA agent, is about to publish a book, and he hasn't gotten permission from us to publish the book, and so we want to stop him from revealing anything that we don't want revealed. So Marchetti and his lawyers sat down with the CIA and its lawyers, and they went through the galley proofs, and they took out a whole bunch of stuff. But Marchetti and his lawyer went back to the CIA and said, look, let's think about these things that you've taken out. And they managed to get the CIA to agree to put back a lot of the things that had been taken out. If I were still in my office, you would be able to come by and take a look at a copy of the book, because the book was published with the redactions required by the CIA. The book has regular typeface, and that it has boldface, the sections that the CIA wanted taken out. And in addition to that, it has blanks for the paragraphs and pages that the CIA said, no, you can't publish no matter what. And you can tell from the space how large the paragraphs were, which gives you an idea in the context of the chapters, what they're talking about. But yes, the CIA was successfully able to get Mr. Marchetti to edit his book because of his agreement. Frank Snepp, also a CIA operative. He was assigned to Vietnam before it, South Vietnam, before it fell to the North Vietnamese. He wrote a book later on called A Decent Interval, in which he talked about what had happened when the North Vietnamese invaded. The North Vietnamese invaded South Vietnam and won. They took over the whole country in a very brief period of time. If you've seen the history books, you may have seen the iconic picture of helicopters on top of the U.S. Embassy building and people going upstairs to get on the helicopters to flee Saigon to American warships in the South China Sea. Mr. Snepp called his book A Decent Interval. In his book, he talked about running operations in South Vietnam, working with people, South Vietnamese people, to provide intelligence for the United States. In his book, he recounts a conversation he had by telephone with a woman who was one of his operatives, and the CIA had promised all the people helping it that if anything bad happened, they would send helicopters to pick up the operatives and their families and fly them away to safety. And when the North Vietnamese attacked and started moving south very quickly, Frank Snepp was on the phone to his operatives and was talking to one woman. And she says, I don't think you're going to come and save us. I just don't believe that. And Mr. Snepp is on the phone saying, no, we promised we would come pick you up. We promised we would save you. So, as soon as I find out when the helicopter is coming for you, I'll call you, and then you can be ready to get on the helicopter and flee south and flee to America. Well, the North Vietnamese advance is just unprecedented in its speed. And now people are getting ready to evacuate Saigon, so Frank Snepp talks to his boss and asks him, when are the helicopters going out for the operatives who've been working for us? And his boss says, they're not. We don't have enough helicopters to do that. All the helicopters have to be used to evacuate Americans from Saigon. And so Mr. Snepp in his book talks about calling this woman back, getting her on the phone and saying, I'm really sorry, but the helicopters are not going to come. We don't have enough. They're going to be used for Americans. And in his book he talks about how the woman says, yes, I knew you were going to do that. I knew you were not going to honor your promise. I'm going to go kill myself and my family rather than be captured by the North Vietnamese. And then she hangs up. Well, a decent interval was Mr. Snepp's expiation of his guilt for doing that. He didn't get permission from the CIA to publish. His book was already published by the time the CIA found out about it, so they couldn't redact it, and they couldn't collect all the copies of the book, so they did the next best thing. They went to a federal court and said, Your Honor, Mr. Snepp is making money off of this book, which he has published in violation of his non-disclosure agreement. We think that he should not profit from that bad act. And so the judge then agreed and ordered that all the money that Frank Snepp made, his advance and all his royalties, be paid to the CIA. Mr. Snepp was not going to see a dime from his bad behavior. And so the CIA was able to use the non-disclosure agreement, not to punish, well, not to impose a prior restraint, but to punish people for violating the agreements. And then we have Wilson versus McConnell. Wilson is Valerie Plame Wilson. Ask your parents about her. In the run-up to the invasion of Iraq, the Bush administration made a lot of claims about how dangerous Saddam Hussein and the Iraqi regime were, claims that proved to be untrue. And they made a lot of claims about the links between Saddam Hussein and the 9/11 hijackers and the links to Al-Qaeda, all of which were proven to be untrue. One of the things that the Bush administration said was, we're afraid if we don't invade that Saddam Hussein will develop an atomic bomb, and then we'll see a mushroom cloud as evidence that we should have acted before. Some of the evidence that they tried to cite for that claim was the attempt by the Iraqis to buy yellow cake uranium from the country of Niger in Africa. Well, Ambassador Joe Wilson went to Niger after the claim was made by the Bush administration. He looked around, came back, and he published an editorial piece in the New York Times under the headline, What I Didn't Find in Niger. And in his editorial, Ambassador Wilson said, there is no yellow cake uranium for sale. I talked to intelligent people in Niger, and this rumor that Niger was willing to sell yellow cake uranium, or that yellow cake uranium was available in Niger, it's all untrue. So the Bush administration's claim, its argument for invasion, is false. It's a lie. Shortly after that, a Washington columnist wrote a column in which he said, well, how can we trust Ambassador Wilson? He just got the assignment to go to Niger because his wife, Valerie Plame, works at the CIA. What the columnist didn't realize is that Valerie Plame was, in fact, an undercover CIA operative. And it's a federal crime to knowingly out an undercover CIA operative. So her cover was blown. She had been an active agent. She did operate intelligence rings in other countries. She could no longer go to those countries because she would be arrested as a spy if she did. The people she had worked with, her rings of operatives, were at risk because now they knew that whoever Valerie Plame had talked to was likely to be a spy for the Americans. Because she was now rendered impotent and useless, she retired from the CIA. And then she decided to write a book. It was a book about her life. The last chapter in the book is how she had to retire, how she was identified by this columnist. And she had to submit her book to the CIA for approval according to her non-disclosure agreement. If you're going to try to disclose something that you learned while you're at the CIA has to give you permission. So the CIA said, well, we're not going to let you publish information about how you had to retire. And Valerie Plame Wilson was, what do you mean? Everybody knows it. When I started at the CIA, when I retired at the CIA, it's public knowledge. It's in the congressional record because a member of Congress read it into the congressional record. And the CIA said, well, we don't care. You can't publish it. So Valerie Plame Wilson sued the CIA. The case made it through the courts, and the courts all ruled that her non-disclosure agreement was binding, that it was lawful, and that she would not be able to publish the information about when she started and when she ended her career at the CIA. Now, if you buy a copy of Valerie Plame Wilson's book, you will see in the last chapter that it talks about when she started at the CIA and when she left the CIA. That chapter was written by a journalist, not by Valerie Plame Wilson. And so the publisher got around the CIA rule that way. But the rule can be effective, and it can impose a constitutional prior restraint, because the Constitution doesn't come into play when you sign a contract saying, I'm giving up my rights. You can give up practically all your rights under the Constitution. Well, there are some you can't. You can't give away your right not to be murdered, but pretty much anything else. For example, when Gray Davis was recalled, ask your grandparents about that. He was governor of California. He was recalled. There was an open election for the governorship. A lot of people ran, including Arnold Schwarzenegger, who became the governor. People working on Arnold Schwarzenegger's election campaign had to sign non-disclosure agreements. And the non-disclosure agreements were, you can't tell anybody anything about what you learned while working for the gubernatorial candidate. And if you do tell anybody, you have to pay us $50,000. And so people kept their mouths shut because they didn't want to have to pay $50,000. If you work for a celebrity, you're likely to be required to sign a non-disclosure agreement. Non-disclosure agreement is the same thing as a prior restraint that you have agreed to. I agree to have a prior restraint on talking about what I learned. Some of you may even have had to sign non-disclosure agreements with your internships or jobs that you've already had. These are contracts in which you give up your right to speak or write about particular things, and they are legal. So prior restraints can be lawful. Prior restraint in criminal speech. United States versus Schiff. Mr. Schiff was promoting his book that talks about the fact, well, from his point of view, that federal income taxes are unconstitutional. And so he was getting people to refuse to pay their federal income tax, and it was causing no end of problem for the IRS and the people who would be prosecuted for tax evasion. Eventually, the U.S. government went to court and got an order to prevent Mr. Schiff from publishing his book and promoting his theories, and the court ruled for the United States and allowed the prior restraint because Mr. Schiff didn't have First Amendment protections for his speech. His speech, telling people not to file their taxes, was criminal speech. It was speech that advanced a crime. Because criminal speech doesn't have First Amendment protection, we didn't have the three-part test. Because there is no three-part test, Mr. Schiff's speech, his publications, could legally be restrained. So be aware of that. Now, apart from prior restraint, the government sometimes does other things to keep people from seeing stuff. In one case, in your textbook, the United States bought the whole first edition of some guy's book, bought thousands of copies because it had some embarrassing information there. And so rather than try to go to court to get a prior restraint, which probably would be unconstitutional, they just said, listen, we'll just buy all the copies of the books. Nobody can read them. We'll just take them, burn them, get rid of them. In another case, the government simply made it impossible for people to use government computers to look at particular websites, like the New York Times and the Washington Post and the Guardian newspaper, because they didn't want military personnel or government employees to read stories about the misdeeds of the government. Now, these people in the military could go home on their personal computers and look at the same thing, but while they were at work, they weren't allowed to look at this stuff that the government deemed to be embarrassing and improper. So, prior restraint, there's a heavy presumption against its constitutionality. There's a three-part test that must be met, and so far we have not had any cases where the three-part test has been met. But in the absence of a general prior restraint, we can use contract law to achieve the same purposes, and we've seen Marchetti, Snip, and Wilson as examples of that non-disclosure agreement being effective in court. And where criminal speech is concerned, there is no protection against prior restraint. Oh, criminal speech. Bank robbers don't claim a First Amendment right to write hold-up notes because it's not protected by the First Amendment. All right, let's move on to an area kind of related to government control of speech, and that deals with forums. We have three kinds of forums. Now, forums can be a physical place or can be a virtual place. And the three kinds of forums we have in the United States are public forums. And public forums are places where free expression has been invited by the government, and there's no control on ideas or speakers. At Cal Poly, we have the free speech boards at a couple of places on campus. One of you has blogged about this. But on the free speech boards, these boards or these walls are places where free expressions have been invited by the government of Cal Poly, and there's no control on what ideas are expressed or who can speak there. And as we've seen, some of the expression on the free speech walls has been highly charged, angry, and upset a lot of people. And the university's response has been, we don't agree with these sentiments, but we are not going to take those sentiments down because this is a public forum. A public forum is, hey, everybody gets to speak on anything and everything they want, as long as it's not criminal. If it's criminal, then there's no First Amendment protection. On the opposite side is the non-public forum, and this is a place where free expression has not been invited or permitted, and the government can prevent the expression of any ideas and prevent any speaker from engaging in publication. Now, one thing to keep in mind is that we're talking about government space. We're not talking about a mall. A mall is private property. And on private property, there is no question about forums, because on private property it is whatever the owner of the property decides to allow and whatever the owner of the private property decides to exclude. You have no right to go to a mall and engage in protests. You could have a right to go to a public place like a public park or a public sidewalk to engage in protest, because the park and sidewalks are, well, they're considered to be traditional public forums. You can't go to the Oval Office in the White House and engage in protest because that's not a public forum. You can't go into the Supreme Court committee rooms or conference rooms and have a protest because that's not a public forum. You can't go to a military base and have a protest because military bases are not public forums. They are non-public forums. Then we have something in the middle called the limited purpose public forum. And here, again, this is government property. The government has allowed the expression of some topics and the expression by some speakers. Apart from those topics and speakers, nobody else has the right of expression, only the ones already authorized. So an example of this would be if you ride a city bus. And when you ride the city bus, you're going to see some advertisements. But these advertisements are for a limited category of goods and services being promoted by a limited category of speakers. Now, only those people and only those topics are allowed. So let's say you're riding on a bus and there's an ad for a television show. Well, that's fine. Now, if you go to the city and say, I want to put an ad on the bus for my hamburger shop, the city can say, well, we don't allow hamburger shop advertising on the bus. And you'll say, but you have advertising for the television show, and the government will say, yes, we allow advertising for television shows by television producers, but that's the only subject and that's the only speaker we allow. We don't allow ads for hamburger joints or hamburger joint operators. And you might say, well, that's terrible. And the city would say, well, it's the law. It's a limited purpose public forum. Only certain topics, only certain speakers are allowed. So keep that in mind. Let's see how things become a public forum. It can be by a dedication by the government. In Hague versus CIO, a case out of 1939, the courts found that city streets were places where anybody could traffic in any idea, any speaker, as long as it was legal, not criminal speech. And so the union there had the right to advocate for union membership and had a right to advocate for better working conditions for employees. And you see the quote there from your book. Streets and parks have been held in trust for use by the public. Now, the case before Hague versus CIO, Davis versus Commonwealth, is an older case in which the Boston Commons, if you've ever been to Boston, you've seen it, was a subject where a guy wanted to preach. And the city fathers in Boston said, we don't like your message. We're not going to allow you to preach. And so Davis sued, and the courts there said, well, the city fathers are the owners of the Boston Common, and so therefore they can exclude speakers if they want to. Hague versus CIO, which came later, reverses that proposition. And you'll notice in the quote, it's streets and parks. So places like the Boston Common, a public park, well, that's a public forum. You can have a public forum by dedication, or you can have public forum by inaction. Here, a later case, if you're on the street, it's a public forum. Now, inaction by the government, Flower versus United States. In Flower, you had a military base in the city of San Antonio. And running straight through the middle of the military base was a street, New Braunfels Avenue. And the street was used by civilians, people not in the military. It was used as a major conduit for traffic, because if you couldn't go through the military base, you had to go around the perimeter of the military base, which made your trip much longer. So for years and years, people had simply driven on this street, which was technically on the military property. Finally, during the Vietnam War, Mr. Flower went there to that street protesting the war. And so he was walking on New Braunfels Avenue, technically on part of the military base property. Military police went and said, you have to stop protesting. We don't allow protesting against the war. And Mr. Flower sued. The case made it to the Supreme Court. The Supreme Court said, this street, New Braunfels Avenue, while it is a part of the military base, has been used by anybody. And so it's become like a regular street. The government has not controlled the topics of discussion. The government has not controlled who is allowed to speak. The government has simply let any idea or expression or speaker travel the street. And because of that, the government no longer can claim that this is a non-public forum. The government's failure to control this means it is a public forum. Mr. Flower has the right to protest. So keep that in mind. That's why the government will shut people down if they try to engage in expression in places which the government doesn't want to be public forums. So there are facts from the case. It was a street that a lot of people used. And there's the special language. The military has abandoned any claim that has special interests in who is on the street. Now, forums can change in nature. The government can open a non-public forum or limited public forum to being a public forum. Number one, by not controlling the topics or speakers. Or the government can dedicate this space. Okay, this used to be a military base. Now we're going to dedicate it to the city as a giant park. In doing so, the government has made the former military base a public forum. On the other side of the coin, if it's a public forum, it doesn't become anything other than a public forum unless the nature of the place changes. So you have an open field owned by the government. If the government then sells that to somebody and that person builds a shopping mall, then that's private property. The nature of the place has changed. Or if you have a street on a military reservation, let's not use the street. You have a, let's go back to the open field again. You have an open field or a park owned by the government. It's a public forum. If the government decides to put a hospital up on the park, then the park land has changed in nature. It's no longer being used as a park. It's now a hospital. The nature of the place has changed, so the hospital is not a public forum, because you can change that. Now, if the nature of the place doesn't change, it remains a public forum. So some of you may have heard of a place called Las Vegas. And in Las Vegas, land is at a premium, land that casinos want to use to put in more slot machines and gaming tables to separate tourists from their money. So some casinos actually purchase the right to extend their casinos up to the street, up to the curb, which means that they now had the sidewalk, which was previously outside the casino, as part of the casino. If you've been to Las Vegas, you'll have noticed that occasionally you'll see groups of men who are handing out little business cards to tourists and passers-by. And these business cards are for, well, young ladies who are willing to exchange a brief period of their time for money by entertaining customers by dancing for them. And sometimes the pictures have pictures of naked girls on them. Well, these groups of men hand these cards out on the public streets, on the public sidewalks. When the casinos extended their casinos out onto the sidewalk, they went to the groups of men and said, you have to get out of here, and you can't hand out your little naked picture business cards because we own the casino and we now own this sidewalk. And lawyers for the companies that hired the men to advertise for the young women went to court. And the federal district courts in cases involving that have said, well, it's still a sidewalk. You haven't changed the nature of the sidewalk. It's being used by people to walk back and forth. Because the nature of the sidewalk hasn't changed, it is a public forum, and you cannot kick out these men handing out the naked business cards. Then we have the LDS Church in Salt Lake City. Of course, you know, the LDS Temple is in Salt Lake City. It's adjacent to downtown Salt Lake City. There are public streets that run alongside and in front of the church. Some people don't agree with the premise for the Church of Jesus Christ of Latter-day Saints, and so folks would walk on the sidewalk outside the temple and shout things at people like, oh, hey, you belong to a cult, you're not a real church, you're going to burn in hell. And that upset folks, because here you are. It's kind of like if people were walking in the Vatican and saying, hey, the Pope is really just a guy in a funny hat. So understand that the property is dear to adherents of the faith. Now, the LDS Church bought Main Street. City needed money. Church wanted to occupy that, own the property. As part of the sale, the city of Salt Lake City retained an easement which would allow pedestrian and vehicle traffic on Main Street. Well, what happened is the church took possession of the land. Protesters came up, started shouting things, terrible things about the LDS Church, and the church called the police and said, get these people off my property. And the protester said, well, it's still a public street, it's still a public sidewalk, you can't keep us from this. Now, they had changed some aspects of the property, as you can see, but the easement said this is public access. The protesters sued. The federal district court said, well, this city easement requiring public access means that it's still a public forum, so you can't ban the protesters. The city and the LDS Church resolved the issue by selling the easement for cash land and a $5 million rec center. The protesters continued their suit. The 10th Circuit Court of Appeals said the easement had been sold, so the protesters could be banned by the church. So a combination of transfer to private property, change in the nature of the place, and then the loss of the easement meant that it no longer was a public forum. So keep that in mind. Public forum unless it changes in its nature. Licensing is here after public forums. And licensing is how the government controls expression in public forums. Governments have inherent police powers. Those police powers exist to maintain public health, public welfare, and the orderly flow of business. And what this means is that on the basis of the exercise of police powers, governments can impose a licensing requirement for speech. So let's say there's something at Cal Poly that you don't like. I don't know, Cal Poly is perfect. What could we complain about other than parking and the food at the campus dining halls? So you and 1,000 of your closest personal friends decide you want to protest the food. And where is it that students like to go to eat and perhaps drink? Well, it's downtown. So your protest is going to make a point of how bad the food is at Cal Poly by turning your backs on the campus eateries and marching along public streets to downtown, where you will compare the food downtown to the food at Cal Poly and chant things about how bad the food is at Cal Poly. Well, you and your couple of thousand friends can pose public health, public welfare, and public safety issues, because you and your 2,000 friends may not just occupy the sidewalks, you may spill off onto the street, which means you're a traffic hazard. You certainly could affect the orderly flow of business by having 2,000 people in the downtown blocking access to the retail establishments. Or if you add another 2,000 people to the farmers market, it could make it more difficult for the farmers market to operate efficiently. So the government could tell you that before you conducted your march, you would have to get permission. And that would be constitutional through the exercise of police powers. Now, police powers apply to group expression. Police powers do not apply to individual expression. There are two different animals, and we're going to see the difference. One of the things about police powers is it has to be content neutral and related to legitimate police power needs. Content neutral means that they can't deny you a license or impose restrictions just because they don't like your particular point of view. All point of views must be treated the same. Police powers allow governments to impose time, place, and manner restrictions, but the restrictions must be reasonable under the circumstances. So let's talk about Village of Skokie versus National Socialist Party. American Nazi Party members wanted to march in Skokie. Sorry about the typo there. They wanted to march in Skokie because it had a large Jewish population. It had a large number of people who had survived the Holocaust. And the Nazi Party members wanted to march in Skokie not because they thought they would get recruits, but instead because they thought they would get a lot of publicity which would promote their cause. Well, the officials in the village of Skokie said, this is terrible, this is going to be upsetting to our residents, and we don't like the Nazis to begin with. They tried to figure out how to keep them out. They passed an ordinance saying you can't march in military-style uniforms in the public. Well, that was a problem, because what was going to happen on the 4th of July when the junior ROTC was part of the color guard for the American flag, or when the Boy Scouts marched in their uniforms, or when people marched in any kind of uniform. The village of Skokie also considered and put into place an economic rule. They said the Nazis are going to have to post an insurance bond of $300,000 for public liability and an additional $50,000 in property damage. And of course, the American Nazi Party didn't have $350,000 to put up, and they didn't have enough money to buy an insurance bond from an insurance company. The village also imposed a ban on distributing materials that incited hatred. And here, of course, you see the ban on marching in military-style uniforms. The case of the American Nazi Party was taken up by the ACLU, the American Civil Liberties Union, of which I'm a member. And the ACLU said, well, yes, we don't agree with the beliefs of the Nazi Party, but the First Amendment stands for everybody having the right to express themselves. And as I explain in classes, the First Amendment protected the Reverend Dr. Martin Luther King, and it also protected Lester Maddox and George Wallace. And history has shown whose ideas were more long-lasting, more relevant. So the ACLU went to court, and the Illinois courts held that the $350,000 insurance bond was unreasonable under the circumstances. the American Nazi Party was going to march on a public street. Yes, they might wear boots, but they couldn't do $350,000 worth of damage just by marching on the streets. So, based upon the context, the $350,000 bond was unreasonable. Now, at this point, some of you are thinking, well, wait a minute. What about fights? The Nazi guys were going to be there, and there might be fights. There might be property damage. Well, there were not a whole lot of Nazis, maybe 70, and they weren't going to be picking fights. So if somebody punched the Nazi or somebody started a fight, should the Nazis be required to have a bond in case somebody else started a fight with them? And that's not permissible, because you could stop any sort of protest by simply saying you have to have a massive insurance bond because someone might start a fight. In fact, you could get agitators to go start fights and therefore make your prediction self-fulfilling. So it has to be reasonable. I used to be a reporter in the Dallas-Fort Worth area, and when I was a reporter there, the city cut back on funding for free public clinics in the poorer parts of the town. And so poor people in Dallas said, we want to have a protest march at City Hall to protest these budget cuts. And the Dallas City Hall people said, well, okay, but you have to post a $50,000 bond. And the poor people said, $50,000? If we had $50,000, we wouldn't have to march. We'd be able to go to our own doctors. And so they challenged the requirement. And the district court, hearing the challenge, said, well, City Hall is in downtown. And the area around City Hall is a giant parking lot. You have asphalt and light poles and a couple of trash containers. There's not $50,000 worth of property to be damaged. Therefore, the $50,000 bond requirement is not reasonable. Other things judged on the reasonableness: if you wanted to have a protest march in Death Valley in July, and the government could say, well, you want to march on this in this public forum, but you're going to have to provide EMTs, you're going to have to provide shade tents, you're going to have to provide water, and you have to provide guides to keep people from wandering off into dangerous places. Because it's a march in such a hostile environment, those requirements would be reasonable, and you would therefore have to meet them. If, on the other hand, you wanted to have a protest in Santa Rosa Park, and the city of San Luis Obispo said, well, okay, but you're going to have to provide EMTs and shade tents and water and guides, well, that would be unreasonable under the circumstances. So everything has to be judged on its context. Now, think about it for a moment. What if there was a requirement for a $1 million insurance bond for a public protest? Would that ever be constitutional? Think about that for a moment. So in Washington, D.C., there's a museum which has the Hirshhorn Gallery, which is, it's kind of like a little park, and it has sculptures. And if you wanted to have a protest march in that little park with the sculptures, which are very valuable, you could see $1 million insurance bond as being reasonable, because the artwork, the sculptures in that little park are so expensive that $1 million would be a reasonable insurance requirement for a protest there. So you always look at the circumstances. Is this reasonable under the circumstance, or is it unreasonable under the circumstance? Now, I've said that licensing and time, place, and manner rules are applicable to groups, but they're not applicable to individuals. So we have Lovell versus City of Griffin. Miss Lovell is a member of the Jehovah's Witnesses. She has gone to the city of Griffin in Georgia. She is doing the Lord's work, going door to door. The city of Griffin had an ordinance saying that if you wanted to go door to door, you had to get a permit from the city clerk, and you had to carry that permit with you, and if anybody asked for it, you had to show it to them. Well, Miss Lovell didn't go to the city clerk. She didn't bother getting a permit because she was, after all, doing the Lord's work. So someone complained about her, and the police went. They found her going door to door. They said, "Where's your permit?" She said, "I didn't have one." They said, "Well, you have to have one because you're in violation of city ordinance if you don't." And her reply was, "I'm doing the Lord's work. I don't need a permit from the secular government." So they arrested her, took her to court. They found her guilty. They fined her $50, and she appealed the case. The case went all the way to the United States Supreme Court. And the Supreme Court ruled, as you can see on the screen, that getting a license for individuals to express themselves was unconstitutional when it was related to the legitimate First Amendment speech. Now, the court said if Miss Lovell had been selling Fuller brushes or vacuum cleaners door to door, then the license requirement would be constitutional. So commercial canvassing, selling things door to door, you can require a license for and be constitutional. But if someone is doing First Amendment activity, Miss Lovell, of course, is talking about religion, a core First Amendment activity, then the licensing requirement was not constitutional. Watchtower versus Village of Stratton. Again, you had people from the Jehovah's Witnesses going door to door in the Village of Stratton. And the village had an ordinance requiring that people go to City Hall, go to the city clerk, register themselves, identify themselves, and get approval from the city clerk in order to go door to door. That case made it to the Supreme Court, which ruled 8-1 in favor of the Jehovah's Witnesses. And the court held that the licensing requirement was, number one, not content neutral because the clerk had to approve what you were going to talk to people about. So that was constitutionally wrong. But then the court said that the ordinance deprived people of three core First Amendment rights. One was the ability to engage in expression spontaneously. And that goes like this. If you go to a party, right, usually about midnight, whoever stays is gathered in the kitchen where they're drinking beer and talking about how things ought to be made better. And they come up with an idea. Well, if we did this, then it would be perfect. Well, if part of your plan for making your city perfect means going door to door, and it's Saturday night at midnight, and you want to start Sunday, well, in the Village of Stratton, you couldn't because you had to wait till Monday to go to the city clerk to get your registration and your permit. So the requirement that you get a license before going door to door meant that you were denied the ability to engage in spontaneous speech. Second, the Supreme Court said that the Village of Stratton ordinance denied people the First Amendment right to engage in anonymous speech, because in the Village of Stratton, you had to identify yourself to the city clerk. You had to show identification before the city clerk would consider giving you a permit to go door to door. And the First Amendment stands for the proposition that anonymous speech is a fundamental expressive right. And the Supreme Court then said that the Village of Stratton ordinance was unconstitutional because it denied people the right to engage in speech without getting prior approval. And of course, the city clerk had to approve what you were going to talk to people about before issuing a license. So, for individuals, restrictions on speech not permitted when you're on public property. Now, some of you are thinking, well, they're going door to door, so they're going on people's private property, and can't people say, get the hell away from my door? People can do that, but only with respect to their own private property. And this is not purely First Amendment, but this is land law, your yard and the sidewalk to your door are what is known as curtilage, curtilage. So when you're a little kid and you're going to play, you're going to school, you cut across people's yards, right? Unless they have the big fence. When you're going trick-or-treating, you're going up on people's sidewalks to ring their doorbell. You're not trespassing. Curtilage means that this is your property, you're paying for, you're paying taxes on it, but it has been the tradition that people can use the property. Back before we had smart meters, meter readers would walk through your yards, sometimes into the backyard, to read the electric meter and the gas meter and the water meter. They didn't have to get special permission because they were on the curtilage. So, as a private landowner, you can, of course, post a notice saying that no canvassing, no solicitors, nobody can come to your door. And if they come to your door, then you have a trespassing claim. But you're not the government. So the government can't do that for you. So for individuals, government controls on speech, as long as it's not criminal speech, not permitted. Here, this slide, you see the three rights that the Village of Stratton Ordinance violated: anonymous, spontaneous, and government permission, which meant that it was not content neutral. Schneider versus Town of Irvington. Here you had a town dealing with people handing out leaflets. Well, if you're walking along and someone hands you a leaflet, and you're like most people, you may look at it, or might not even look at it, but as soon as you're 5 or 10 steps away, you just drop it to the ground. In the town of Irvington, they made it a crime to litter, and they said it's not the person who dropped the leaflet to the ground, it is the person who handed the leaflet to the person who's guilty of littering. And of course that was challenged, and the court said, well, that's really inventive and smart, but too bad, so sad. No, you can't use anti-littering to restrict speech. Similarly, in Cincinnati versus Discovery Network, the federal courts held that Cincinnati, which was using anti-littering rules to take news racks off the street because people were littering with the content of the news rack, they said that's not permissible. You can't use anti-littering to restrict expression. The Discovery Network had one of these things where they have these free flyers, little newspapers, make money in your spare time, take these classes, and they were in news racks that were free, kind of like on campus. Occasionally you may find a news rack for the Mustang, the ones that are still there. You just open them up, take a paper. Well, for these Discovery Network news racks, they were in throughout the downtown area, and kids would go and reach in, take a bunch of the little newspapers, fling them in the air to make an effect of like snow falling, or just litter for the heck of it. And the city of Cincinnati said, well, we're having to clean up around these news racks. Unless you can guarantee that people won't litter, we're going to take your news racks off the streets. And the courts, just as in Schneider versus Town of Irvington, said you cannot use an anti-littering ordinance to restrict expression. We've talked about prior restraint. Here we have something called forcing communication to occur. The case of Miami Herald versus Tornillo. It is pronounced Tornillo, not Tornillo. There was a Florida statute requiring that if a newspaper ran an editorial against somebody, let's say two people were running for mayor, and the newspaper said, well, we like Joan Smith for mayor, we're endorsing her, and we don't like Jack Doe for mayor, so we're not endorsing him. In fact, we're saying don't vote for him. Well, the Florida legislature, in order to ensure that people got a fair shake, said that if a newspaper ran an editorial that opposed you, you had the right to write your own editorial, and the newspaper was required to publish it. Well, Mr. Tornillo was a candidate in a political race. The newspaper endorsed Mr. Tornillo's opponent and also said, we don't like Mr. Tornillo because of this, that, and the other thing. Mr. Tornillo, relying upon the statute, then wrote his editorial reply, took it to the newspaper, said, "Here, publish this," and the newspaper said, "I don't think so." And they refused to publish his responsive editorial. He sued, and the state district court ruled for him and against the newspaper. The state Supreme Court ruled for him against the newspaper. The case made it to the United States Supreme Court, and the United States Supreme Court held that the statute was unconstitutional and that Mr. Tornillo would lose. Constitutionally, the statute took away the power of the newspaper editors to choose content and allowed the state to dictate the content of the newspaper, and that was a violation of the First Amendment rights of the newspaper. And the opinion spoke about how the statute could, in its extreme, fill up the entire newspaper with content that the state required that the newspaper published. The state could not intrude upon the editorial province. That's the only case we have about forcing communication to occur, because the Tornillo case meant that everybody knew they would be unconstitutional, so they don't even bother trying. We'll move on to hate speech in the next video, because my voice is running out. So continue to send your blogs. I'm going to do a response to blogs on Wednesday, so if you have questions in advance of the test, please send them along. I'm anticipating that I will have the last of the video lectures for part 1 of the course done sometime later today, and then they will be available to you. Thank you.